Welcome to the AskJunior Labor and Employment Law September 2024 podcast. I'm Sarah Mehta, and joining me today is Arun Kapoor.
Hello, everyone. We're excited to dive into this month's important labor law judgments. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our monthly legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest employment law decisions. Today, we'll be doing a deep dive into several groundbreaking court decisions that are reshaping India's employment landscape.
Let's start with the Ushaben Joshi case against the Union of India, which addresses a critical issue many contingent workers face, the right to regularization.
This is such an important case for understanding workers' rights. Could you give our listeners some context about contingent workers in India?
Certainly. Contingent workers, also known as temporary or casual workers, often work alongside permanent employees but without the same benefits and job security. They've historically faced challenges in getting their positions converted to permanent roles, even after years of service.
And in this case, what specific situation did Ushaben Joshi face?
Ushaben Joshi worked in the Posts and Telegraphs Department as a contingent worker. Despite having a similar service record to other workers who were regularized, she was denied this benefit. The crux of her argument was that this differential treatment violated her right to equality under Article 14 of the Constitution.
Could you explain what criteria the Supreme Court looked at in determining whether this was discriminatory?
The court focused on several key elements. First, they examined the department's circulars, which stated that employees with continuous service of over 240 days were eligible for regularization. They also looked at comparative cases where other workers with similar or even shorter service periods had been regularized.
What was the department's defense in this case?
The department tried to justify the differential treatment, but the court found their explanations inadequate. They couldn't provide any reasonable basis for why some workers were regularized, while others, like Ushaben, were left out despite meeting the same criteria.
And what principles did the court establish in their judgment?
The court emphasized several crucial principles. First, they reinforced that similar situations must be treated similarly in employment matters. Second, they established that once an organization sets criteria for regularization, they must apply these consistently. Finally, they highlighted that arbitrary differentiation between similarly situated employees violates constitutional principles.
What specific remedies did the court order?
The court directed the department to regularize Ushaben's employment with all corresponding benefits, making it effective from the date when the similarly situated worker was regularized. They gave a 3-month timeline for implementation and ordered that all consequential benefits be provided.
What implications does this judgment have for other contingent workers?
This judgment sets a powerful precedent for contingent workers across India. It effectively says that if an organization has regularized some workers, they can't arbitrarily deny the same benefit to others in similar positions. It also reinforces the importance of maintaining consistent employment practices.
Moving to our next significant case, let's discuss SD Manohara versus Konkan Railway Corporation Limited. This addresses a common situation many employees face, the withdrawal of resignation.
Yes, this case provides crucial clarity on resignation rights. The basic question was whether an employee can withdraw their resignation before it's formally accepted.
Could you walk us through the specific timeline of events in this case?
Certainly. On April 15, 2014, Mr. Manohara submitted his resignation. However, before receiving any formal acceptance, he attempted to withdraw it. The Railway Corporation claimed they had already processed and accepted the resignation internally, but crucially, this acceptance wasn't communicated to him.
What were the legal principles the Supreme Court considered here?
The court examined several fundamental principles of employment law. First, they emphasized that resignation is essentially an offer to terminate employment. Like any offer under contract law, it needs acceptance and communication of that acceptance to become binding. They also looked at the principle of legitimate expectation in employment relationships.
How did the court view the internal acceptance claim by the employer?
The court was quite clear that internal processing or acceptance without proper communication to the employee has no legal standing. They emphasized that proper communication is not just a formality, but a substantive requirement for making the resignation effective.
What broader principles did this judgment establish about resignations?
Several important ones. First, employees have the right to withdraw their resignation before it's properly accepted and communicated. Second, employers must have clear procedures for handling resignations. Third, internal communications or notings don't constitute valid acceptance without proper communication to the employee.
What specific relief did the court grant?
The court ordered reinstatement within 30 days and awarded 50% of the salary for the period following the alleged relieving date until reinstatement. Importantly, they also directed that this period would count towards pensionary benefits.
Let's move to another significant case. Minakshi Chaudhary versus Rajasthan State Road Transport Corporation. This case addresses the evolution of maternity benefits in India.
Yes, this case highlights the tension between older regulations and modern legal standards regarding maternity leave. The basic issue was whether an employee was entitled to 180 days of maternity leave when the corporation's regulations only provided for 90 days.
Could you explain the backdrop of maternity leave laws in India?
The landscape of maternity benefits has evolved significantly. The Maternity Benefit Amendment Act of 2017 extended the statutory maternity leave period to 180 days. However, some organizations were still following older regulations that provided for shorter periods.
What was the core legal issue before the Rajasthan High Court?
The court had to determine whether limiting maternity leave to 90 days was discriminatory and violated constitutional rights, particularly in light of the 2017 amendments to the Maternity Benefits Act. They approached this from both a statutory and constitutional perspective. First, they examined whether the 2017 amendments superseded older regulations. More fundamentally, they considered whether maternity leave is a fundamental right under Articles 14 and 21 of the Constitution.
How did the court view the relationship between maternity leave and constitutional rights?
The court took a progressive stance, viewing maternity leave not merely as a statutory benefit, but as an integral aspect of a woman's dignity and identity. They emphasized that it's essential for both maternal and child welfare, making it a fundamental right protected under the Constitution.
What specific orders did the court issue?
They directed the corporation to grant the petitioner an additional 90 days of maternity leave with all consequential benefits. They also recommended updating the relevant regulations to align with current legal standards, giving a 3-month timeline for implementation.
Let's transition to the Lily Packers Private Limited versus Vaishnavi Vijay Umak case, which addresses the validity of lock-in periods in employment contracts.
This Delhi High Court judgment is particularly relevant given how common lock-in periods have become in modern employment contracts. The case examined both the constitutionality of lock-in periods and whether disputes about them can be resolved through arbitration.
Could you explain what lock-in periods are and why companies use them?
A lock-in period is a contractual clause requiring employees to work for a specified minimum period. Companies typically use them to protect their investments in employee training, maintain operational stability, and prevent frequent turnover, especially in knowledge-intensive industries.
What were the key legal questions before the court?
The court had to address two main issues. First, whether lock-in periods violate fundamental rights under Articles 19 and 21 of the Constitution. And second, whether disputes about these clauses can be resolved through arbitration rather than regular courts.
How did the court analyze the constitutional challenge?
The court found that lock-in periods don't inherently violate fundamental rights when they're formed through mutual consent and serve legitimate business needs. They emphasized that such clauses are part of the freedom to contract, provided they're not unreasonable or unconscionable.
What about the arbitrability question?
The court ruled that disputes relating to lock-in clauses are arbitrable. This is significant because it means such disputes can be resolved through potentially faster and more cost-effective arbitration proceedings rather than lengthy court battles.
Now let's turn to a truly groundbreaking case from the High Court, Supriya Jena versus State of Odisha. This judgment marks a significant evolution in how we think about maternity rights in the context of modern reproductive technologies.
Absolutely, Sarah. This case is particularly significant because it addresses a gap in existing maternity benefit laws regarding commissioning mothers, women who have children through surrogacy arrangements.
Could you first explain for our listeners what exactly a commissioning mother is in the legal context?
Of course, a commissioning mother is a woman who uses a surrogate to carry and give birth to her child. While she may be the biological mother and will be the legal mother of the child, she doesn't physically carry the pregnancy. Until now, this has created challenges in accessing maternity benefits that were traditionally linked to physical pregnancy and childbirth.
What were the specific facts of the Supriya Jena case?
Miss Jena was a government employee who had a child through surrogacy. When she applied for maternity leave, her request was denied because existing service rules didn't explicitly provide for maternity leave in surrogacy cases. The authorities argued that since she hadn't physically given birth, she wasn't entitled to maternity leave.
This raises an interesting question about how we define motherhood in the context of employment benefits, doesn't it?
Exactly. The case really forced the court to grapple with how traditional definitions of maternity need to evolve with advances in reproductive technology. The core question was whether the purpose of maternity leave is solely related to physical recovery from childbirth or whether it serves broader purposes related to bonding and childcare.
How did the High Court approach this question?
The court took a remarkably progressive approach, examining the issue from multiple angles. First, they looked at the constitutional framework, particularly Articles 14 and 21, which guarantee equality and the right to life with dignity. They emphasized that maternity benefits are not just statutory rights, but fundamental rights linked to a woman's dignity and identity.
Could you elaborate on the constitutional reasoning?
The court made several key points. Under Article 14, they found that denying maternity leave to commissioning mothers created an artificial and discriminatory distinction between different types of motherhood. Under Article 21, they recognized that the right to reproductive autonomy includes the right to have children through surrogacy, and that this right would be meaningless if it resulted in discrimination in employment benefits.
What about the argument that existing rules didn't specifically provide for such situations?
The court firmly rejected this bureaucratic approach. They held that the absence of explicit provisions for surrogacy in existing rules couldn't justify discrimination. They emphasized that laws and rules must be interpreted in light of evolving social realities and technological advancements.
The court also looked at comparative cases from other jurisdictions, didn't they?
Yes, they conducted a comprehensive review of how other courts and countries have handled this issue. They cited cases from various high courts and international jurisdictions that had recognized the rights of commissioning mothers. This comparative analysis helped establish that providing maternity benefits to commissioning mothers is becoming a global standard.
What scientific evidence did the court consider?
The court looked at medical and psychological research about the importance of maternal bonding in the early months of a child's life. They noted that this bonding is equally important whether the child is born through natural birth or surrogacy. They also considered research showing that the challenges of early childcare and the need for parent-child bonding are identical in both cases.
What specific orders did the court issue?
The court issued several far-reaching directives. First, they ordered that the petitioner be granted 180 days of maternity leave, equal to what other mothers receive. They also directed that she receive all associated benefits that come with maternity leave. But they went further. They mandated that the state government amend its rules to explicitly include provisions for commissioning mothers.
What timeline did they set for implementation?
The court gave very specific timelines. The immediate relief, the grant of maternity leave and benefits to Miss Jena, had to be implemented within 2 months. For the broader regulatory changes, they gave the government 3 months to amend their rules to include provisions for commissioning mothers.
Are there any particular challenges employers might face in implementing this judgment?
Yes, employers will need to review and potentially update their maternity leave policies to explicitly include commissioning mothers. They'll need to consider how to verify surrogacy arrangements while respecting employee privacy and how to ensure equal treatment of all types of maternal situations.
Any final thoughts on the broader impact of this judgment?
This judgment really represents a paradigm shift in how we think about maternity benefits. It recognizes that parenthood and the need for parental bonding transcend the physical act of giving birth. It's also a powerful example of how courts can adapt traditional legal frameworks to accommodate technological and social changes.
Finally, let's discuss the MSX case against ANI Technologies, which has major implications for the gig economy.
This Karnataka High Court judgment fundamentally reshapes how we think about platform companies' responsibilities towards worker safety. The case involved a sexual harassment complaint against a driver working with a taxi aggregator platform.
What was the company's initial position?
The platform company argued that their internal complaints committee had no jurisdiction because drivers were independent contractors, not employees. This highlighted a common strategy used by platform companies to avoid employer responsibilities.
How did the court address this classification issue?
The court took a broad view of the employer-employee relationship, looking at the actual control exercised by the platform over drivers through pricing, scheduling, and service standards. They found that this control was sufficient to create an employment relationship for the purposes of sexual harassment protection.
What specific orders did the court issue?
They mandated a prompt investigation by the Internal Complaints Committee, ordered compensation for the petitioner, and imposed penalties on state authorities for their inaction. They also required the implementation of comprehensive safety measures for taxi services.
Now that we've covered the significant court judgments, let's dive into some major developments in labor and employment law that our listeners need to know about.
Absolutely, Sarah. The first significant change is the introduction of the Centralized Pension Payment System, or CPPS, for pensions under the Employees' Pension Scheme 1995.
This is quite a game changer for pensioners, isn't it? Could you explain what CPPS brings to the table?
The Ministry of Labor and Employment announced this on September 4th, 2024, and it's set to launch on January 1st, 2025. What makes it revolutionary is that it creates a national-level centralized platform for pension payments. Pensioners will be able to receive their payments through any bank branch across India.
What's the technology behind this system?
It's part of the EPFO's centralized IT-enabled system, known as CITES 2.01. Eventually, it will transition to an Aadhaar-based payment system. This eliminates the need to transfer pension payment orders between offices when pensioners relocate or change their bank.
How does this benefit retired workers specifically?
It's particularly beneficial for those who return to their hometowns after retirement. They won't face the bureaucratic hurdles of transferring their pension accounts or dealing with multiple offices. It's a significant step toward financial inclusion and ease of access for pensioners.
Moving on to another important development, the new SheBox portal. This seems like a significant step forward in addressing workplace harassment.
Yes, launched on August 29, 2024, by the Ministry of Women and Child Development, this updated portal brings several crucial improvements to how workplace harassment complaints are handled.
What are the key features of this new portal?
It creates a centralized platform for compiling information about internal committees and local committees nationwide. Importantly, it allows complainants to submit their grievances directly to the relevant committee. The portal will become fully operational once all government departments and private sector entities update their committee information.
What's the timeline for implementation?
The government aims to have all central ministries and departments on board by October 2024. This includes updating details of nodal officers and internal committees. It's a phased approach to ensure comprehensive coverage.
Let's talk about the registration of gig and platform workers on the eShram portal. This seems particularly relevant given the growing gig economy.
Absolutely. The Ministry of Labor and Employment is taking significant steps to bring gig and platform workers under the Social Security umbrella through the eShram portal.
What exactly does this initiative offer these workers?
It provides them with a universal account number, UAN, that helps them access various benefits, skill development opportunities, job matching, and eligibility checking for Social Security schemes. It's essentially creating a formal identity for workers in the informal sector.
How are platform companies involved in this?
The government is actively working with platform aggregators to facilitate worker registration. They've completed API testing to ensure smooth integration with the portal. Companies are being encouraged to participate in onboarding both themselves and their platform workers.
There's also been some movement at the state level. Karnataka has extended the timeline for gratuity insurance, right?
Yes, on July 4th, 2024, Karnataka extended the deadline for obtaining gratuity insurance from 60 days to 6 months under their Compulsory Gratuity Insurance Rules 2024. This gives employers until July 10th, 2024 to comply.
And Maharashtra has made some changes to their shops and establishments rules.
That's right. The Maharashtra government has introduced new insurance documentation requirements. They've added Forms A, D, and F regarding insurance certificates and Form R for insurance policy numbers and validity dates. These changes strengthen the documentation framework for establishments.
Tamil Nadu has also made significant changes to their shops and establishments framework, haven't they?
Yes, they've introduced comprehensive changes effective July 2nd, 2024. Let me break down the key aspects.
Please do. This affects a lot of businesses and workers in Tamil Nadu.
First, there's a new registration process. Establishments with 10 or more workers must register online through the Labor Department's web portal. Existing establishments have until July 2nd, 2025 to comply. The registration fee is $100, and certificates should be issued within 24 hours.
What about workplace safety requirements?
They've introduced specific first aid requirements. One first aid box for every 150 employees, marked with a red cross. They've also significantly increased penalties for violations, from Rs. 50 to Rs. 2,000.
West Bengal has made some changes specifically for IT employees, hasn't it?
Yes, effective July 1st, 2024, they've modified work timing regulations for IT sector establishments. While these companies are exempt from the standard 8 5-hour workday requirement, they can't exceed 9 hours per day or 48 hours per week.
And there's been movement on employment opportunities for persons with disabilities?
Indeed. West Bengal issued a notification on August 30th, 2024, requiring establishments to report vacancies designated for individuals with benchmark disabilities to the Special Employment Exchange for Physically Handicapped.
Punjab has made some interesting changes regarding business operations, hasn't it?
Yes, on July 15th, 2024, Punjab allowed establishments to operate 365 days a year until May 31st, 2025. However, this comes with important conditions. Businesses must hire additional staff, obtain written consent from female employees for work after 8 p.m., and ensure proper safety measures in transportation.
Let's not forget the Himachal Pradesh Factories Amendment Rules.
Right. Effective August 30th, 2024, these amendments increased various fees and established a framework for recognizing competent persons for safety and inspection roles. They've also updated the qualifications required for these positions.
And finally, Goa has made changes to their disability rights framework.
Yes, on September 19th, 2024, they amended their Rights of Persons with Disabilities rules, streamlining departmental responsibilities and recognizing the Department of Social Welfare as the Department for Empowerment of Persons with Disabilities.
These developments really show how labor law is evolving across different sectors and states.
Absolutely. From digital initiatives like CPPS and SheBox to state-level changes in working conditions and safety requirements, we're seeing a comprehensive modernization of India's labor law framework.
And that brings us to the end of our coverage for September 2024. We hope our listeners found this detailed analysis helpful in understanding these important legal developments.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you monthly updates on the most important employment law decisions.
Absolutely. And don't forget to tune in next month for another exciting episode. Until then, this is Sarah Mehta.
And Arun Kapoor signing off. Thanks for listening to the Ask Junior Labor and Employment Law Podcast.